Hello folks, this is Abhinay Gupta from Edupedia World, and today again we'll continue with the topic declaration and payment of dividend. As we have already seen in our previous lectures that the chapter of declaration and payment of dividend in our CA final course consists of basically 5 sections, which are section 123 to section 127. Among these, what we've already covered is section 123, 24 and 25. Today we'll move ahead and see what does section 126, 127 has to say and what are the other provisions of the Act and the rules. So moving ahead, we have section 126, dividend to be held in abeyance. That means the suspension of dividend held back by the company, which means that the company shifts the dividend due to the unpaid dividend account instead of paying it to the transferee or receiver of the dividend. So the basic object of section 126 is to ensure that when the transfer of share is pending from a transferor to the transferee, then the right to receive the dividend remains intact with the receiver of the dividend. So the provisions of section 126 say that wherever there is a duly signed transfer deed which the transferor has deposited with the company, but due to some or the other reason the transfer of share has not been registered with the company in its registrar of the shareholders, so in that case the company holds the dividend in abeyance. So what does the company do is they transfer the dividend in relation to those specific shares to the unpaid dividend account, and unless the registered shareholder has authorized the company in writing so as to pay the dividend to the transferee to whom the shares have been transferred, the company will not pay the transferee the required amount of dividend. And the same case, the payment of dividend, they also treat the right and the bonus shares. Even if the company is issuing some right shares or the bonus share to the shareholders, they will hold that back. That means they will suspend the declaration and transfer of that right and bonus share. And this section is a very powerful section. It will apply notwithstanding anything contained in any provisions of the Act. So this overrules all the other provisions of the Act. So hence, if the transfer deed is pending, if the transfer is not registered, the company has the right to hold the dividend in abeyance. They will not give it out unless and until it is confirmed, unless the transferor confirms the transfer. There has also been a case study on the same section, which was between SV Nagarajan versus the Lakshmi Vilas Bank Limited. The hearing of the case, the results of the case were to decide that in any case, if the signatures of the transferor of the share does not match, that means the transfer is not legally acceptable. So in that case, section 126 has no role to play, because that is nowhere a transfer in progress. It is void ab initio. Section 126 comes into play when the duly signed transfer deed is deposited. Mark the words. These are the words of the section. Duly signed transfer deed is deposited. But in this case, it is not duly signed. The signature is wrong. So the case of SV Nagarajan and Lakshmi Vilas Bank specifies the action of section 126, the place where section 126 comes into play. Right? And then we move on to section 127, which is the failure to distribute dividend within 30 days. When the dividend is transferred to the unpaid dividend account, right? Because as we know, the dividend has to be paid within 30 days from the date of its declaration. When we have already seen in the previous lecture that once the dividend is declared, the amount of dividend that the company has decided to discharge has to be transferred to a separate account within 5 working days, and then it has to be paid to the receiver within 30 days. And now in section 127, what we see is the cases when the company is not able to pay the dividend in 127 days. the dividend as per section 127 within 30 days. In that case, what are the exceptions and what are the penalties that will come upon the director as well as the company? And payment and distribution of dividend will also include the dividend warrant being posted. If the dividend warrant is posted by the company within the time period of 30 days, that will not be considered as failure to distribute dividend. That is the basic thing that we need to understand. The dividend warrant is equivalent to paying the dividend, right? Now we come down to see what are the exceptions, like the cases where the default is deemed to have been committed by the company. I mean, no default has been deemed to have been committed by the company. Now, what are those cases? What are those exceptions? There are 5 basic exceptions for these. First being, if the dividend has not been paid by operation of any law. If there is any law that comes into force that forbids the company from paying its dividend or to pay it to a particular shareholder, or in any other cases where the dividend had to be held back by the company due to the provision of any of the law, operation of any law. The second exception is where the shareholder has made it impracticable, which means if the shareholder has given any direction to the company that okay, this is the medium, or this is the mode, or this is the person to whom you have to discharge the dividend, and that direction cannot be complied with, the company is not able to comply with what the shareholder has demanded, the route that it has asked to follow, then, and due to that specific consideration of the shareholder, if the company is not able to pay dividend and the company within due time communicates the same to the shareholder, then the company will not be considered to be at fault. Otherwise also, if the dividend is lawfully adjusted, like there was something the company had to receive from the shareholder, and the company sets it off against the dividend, and that act has been done lawfully, the company is able to justify it, then in that case also the failure will not lie upon the company. Other cases when it's beyond the control of the company, like if there's a dispute regarding the right to receive the dividend, so even the company is confused as to whom to give it, so the company will wait for the court to decide, or for them to settle it amongst themselves, the shareholders, as to confirm that who is the real shareholder, the real owner of the shares, who is ought to receive the dividend. Once it is confirmed, the company will discharge the dividend. But if that period of confirmation takes more than 30 days, then company will not be deemed to be guilty for failure of distribution of dividend. And otherwise, the fifth point that is included is a very generalized point. A general point which says that with the non-payment of dividend, where the company doesn't pay dividend, which is not due to any default of the company. Now it's a general clause that has been brought in, so that if there is any specific case that comes up in future that has not been dealt with, or there's no case law upon it, so they have kept an open scope for that if it is not due to the fault of the company will not be penalized for the same. And the company, now what are the penalties that we're talking about? First thing, the penalty to the director. A director who is at fault for not paying the dividend or for not discharging the dividend due to any particular shareholder, and if he's knowingly, the most important thing is if that director is knowingly a part of that default, he shall be liable for a simple imprisonment of 2 years. He shall be, right? And that means on top of that imprisonment, that director will have to pay a penalty of ₹1,000 per day of default. That is, for example, if the dividend is paid post 60 days of declaration, then he'll have to pay a fine of 60 minus 30, because 30 days period they already have in the hand. So 60 minus 30, the remaining 30 days, ₹1,000 per day. So 30,000 rupee is the fine that the director will have to pay personally. And the liability that comes over to the company is nothing but 18% interest on the dividend that was due to payment. That will be 18% per annum, calculated on number of days, on the basis of the day the default continues. Because company, we know, is not a person of legal identity. We won't lift the corporate veil for this, because we already know the particular director who is at fault, he will be penalized separately and the company is penalized separately. And section 127 has been a very important topic from your exam point of view in the past. As you can see, I have mentioned below on CA final number 2013. In 2013, they had asked you questions about the liability, that is the penalty portion, to the director and to the company. The kind of questions that company puts forward is, they don't ask you, please mention the penalty or to the company or to the director. What they do is they give you a case study. And based on that, you will have to calculate, okay, these are the number of days. Within 30 days, the dividend had to be paid. They have been at default because it's, for example, 45 days. And so this would be the penalty that you may have to calculate too in the question. So you need to be thorough with the numbers, with the exact penalty amounts, right? The number of days. These are things that has to be on your fingertips so that you are able to answer the questions in a more effective way, right? You can be more precise and up to the point for answering. And in November 2014, you were asked about the consequences for non-payment of dividend, or consequences on payment of dividend. To be specific, they had asked in your question for 45 days. Now what are the consequences that will follow? So you'll have to mention everything over there, right? The same thing. So this penalty being important, it has been asked twice, and that too very recently. So it lays very important for your future examinations too. Now with this, our basic sections that we were talking about in our previous lectures too comes to an end. These were the 5 main sections that had to be dealt in this chapter. So now we'll move ahead to the other provisions of the chapter. The first being revocation of dividend. So generally dividend cannot be revoked. It simply cannot be revoked. To get deeper into this section, it's not a section. To get deeper into the topic, we would again go back and refer to section 127, the failure to distribute dividend. Section 127 says that dividend once declared has to be paid out within 30 days. That must be paid out. So that is what the law says, that once it is declared, it must be paid out. But again, section 127 has 5 exceptions for the same. But revocation of dividend, if you have noticed, is none of them. It is not included in the exceptions for the payment of dividend. Hence, dividend cannot be revoked. This is the interpretation of section 127 that we have already dealt with, right? But again, even revocation of dividend has 2 exceptions. There are 2 grounds given by the Companies Act 2013 where even the dividend declared can be revoked. The first among it being an ultra vires declaration, which is that the dividend is declared, like although the company has not earned any profit, the shareholders may have asked the directors, please let's do it this time. Do one thing, you propose this % of dividend, although yeah, come on, it doesn't matter to you. We'll approve it, we'll get the dividend, we'll see to the profit next year, or let's do it some way or the other. Like if they are trying to play around beat around the bush and find out a way of declaring a dividend which is ultra vires, then in such case it is considered to be illegal, first of all. And if it is paid even after the declaration, ultra vires declaration, then the director who was involved knowingly shall be liable to indemnify the company for the amount of dividend they have given to the shareholders. And in that case, the director is personally liable. So ultimately what the law aims to do is to help the company not to lose the money. Right? If there is something faulty going on the hands of the shareholder or in the hands of the director, what the act wants is that the company should not be hampered. The operations should continue. So if the money goes out to the shareholder in an ultra vires way, then the company wants the director to give it back to the company, right? It's as simple as that. And the second case where the dividend can be revoked is where after declaration there arises a situation that leads to affect the going concern of the company. Any condition due to which the company may cease to exist. So in that case, that is a tragic situation and it's an emergency call. So in that case, the dividend that has been declared can be revoked. So these are the two basic grounds that has been specified by the Companies Act when the dividend can be revoked. Otherwise, if the dividend is declared, it has to be paid. It must be paid within 30 days of declaration. That is as per section 127 that we have already dealt with. Right, folks? And we must also keep in mind that in this case, if the director or the company, if they are at fault, but for revocation, if the director is at fault, right? In case of going concern also, it's giving out dividend, otherwise dividend is also being paid, or unnecessary it has been revoked or something, then in that case, we need to understand which is the court who will have the jurisdiction over the case. So declaration of dividend is the act that has to be taken forward from the registered office of the company. So if the work is being done at the registered office, the location of the registered office is very important. So the judge who has the jurisdiction, or the court that has the jurisdiction over the area where the registered office is situated, located, it is registered, right? That is the court which will have its jurisdiction over these cases. And this was also confirmed in a case study of Hanuman Prasad Gupta and Hiralal. And lately it has not been a very important topic from the point of view of the CA Institute. It has not asked a lot of questions. Like no question has been asked from this particular topic in the past 7-8 years. The last question that was asked was in November 2008. There was a flat question, direct reference. So this topic may not be very important for your exam point of view, but obviously since it's a short one, just go ahead with it. So moving on, we have the next topic, which is the payment of interest out of capital, right? So first we need to understand what do we mean by the statement payment of interest out of capital. Now this portion is dealt by section 208 of Companies Act 1956, which was the old act, right? So it was a specific section introduced for a specific case. Now what was that case? For example, there's a company into the construction work who is building a plant, machinery, entire factory or setup, industrial setup, and they know that the setup will be earning profit after a certain period of time. Like they'll take a longer period to build up and construct and then start the work and then sell it and earn profit. So it will take a period of 3-4 years or something. So in that case, when the company wants fund to build up the industry, what they do is they give out shares. Okay, this is the share we roll out in the market. People will subscribe for those shares. They'll pay, and the money that comes from that will be used to build that industry. So what will happen in this case if you step into the shoes of a shareholder? If you being a shareholder, you will not want to interest in that kind of a company, because you know that the company will not be able to pay you the dividend for the next 4-5 years, because even after it comes into operation, then also for like earning a substantial amount of profit so that it is able to pay the dividend after the retention, it will take some time. So people are a little reluctant, the shareholders, investors will be a little reluctant to invest in these kind of companies. So that was a specific reason why section 208 was introduced in Companies Act 1956. The section, what does the section say? That in case, like in this case where you're not able to pay dividend to the shareholders, there are specific circumstances, on fulfillment of circumstances when, and on fulfillment of certain parameters, that the company will be allowed to pay interest on the capital that they have taken from the investors. So like if I'm a shareholder and I have invested rupees 1 crore in that company, then this section allows the company to pay me interest on the amount I've spent in the company, I've invested in the company, right? And that interest that I'll be getting will at no point of time reduce the amount of paid up share capital that I have. That will be an over and above payment made to me out of gratification, or in exchange, or in place of the dividend that I would have received if I would have invested in a good company that would be earning dividend, earning profit to give me dividend, right? So to promote this, This is a specific section that was introduced. Now let's see what this section has to say. The first thing that the section says is that it will be done only if the capital was raised for the said purpose. So what is the said purpose? The said purpose was the construction of the plant, machinery, or the industry, the entire setup. If you have taken up capital for that particular purpose, you may give interest to that particular capital. Like you may give on the interest to the shareholders of that particular share, right? If they know that they are investing for this. But yeah, there are certain basic parameters that has to be fulfilled, which being, first thing is the authorization. Who needs to authorize this payment of interest? The first thing is the article of the company, the article of association of the company that is going up for this construction of plant, machinery, the industry. It has to mention its article. It has to be authorized by its article to pay dividend, to pay interest instead of dividend to the shareholders for the period they are not earning the profit. And along with it, once the article authorizes you, it's well and good, you can go ahead. But in case you failed to mention a clause in the article for the same, even then the shareholders have a chance. What they can do is they can pass a special resolution that okay, we sanction the company to give us an interest. Yeah, the power is given to the shareholders, no doubt about it, but it's a special resolution, right? So a majority of the shareholders, they will have to say yes for this, right? But the power is not given to the shareholders blindly, or the whole control is not given over to them. They have to seek the prior approval of central government for the same thing. Once the central government approves, okay, this is a case we can consider, go ahead, take the interest. So after that, after the procedure is done, they'll have to pass the special resolution. So that's a two-way process, right? And yeah, once the central government grants you the sanction, that is a conclusive evidence that okay, this capital was taken for the purpose, right? That was the first condition, if the capital was raised for the said purpose. So if the central government is giving you the sanction, it's a conclusive evidence. You don't have to get into further detail to analyze whether it was taken for the said purpose. And now the question is, what is the time period for which the interest will be paid by the company? So the time period will be specified by the central government, the first thing. And what the act says is that the time period in no case will extend beyond the half year. Like the say the half year of 2015, the first half is when the construction comes to an end. So the clause says that the second half of 2015 will be the maximum limit. That if your construction, the purpose for which you have taken capital, is completed in one half of the year, then the half that comes after that half will be the last period till which you can pay the interest. Because after that you'll get into operation and you will be in a position to pay off the dividend. So it's a logical thing to do, right? And the rate of interest, the maximum rate of interest has been specified to be 4% per annum. The act says in no case it shall not exceed 4% per annum, or any other rate that is notified by central government from time to time. That 4% can be altered, but it will be altered by the notification passed by central government in the official gazette, right? Yeah, the interest that the company pays to the shareholders. Now, how do they show it in their balance sheet? What they do is they will charge this interest as an expense for the cost of construction. The act allows them to do so. So the question is actually not to be covered in law. It is the question of your accountancy. But yeah, the Companies Act gives you allows you to charge that interest as an expense for the cost of construction. And yeah, one more point is, why do we consider the sanction of central government to be a conclusive evidence that the capital was raised for the said purpose? Is because the central government also puts up an inquiry before sanctioning it. It sends a person to inquire into the matter and send a report back to the CG. And for this purpose also the central government takes the money from the company. The company has to give a security, whatever central government demands, before making the inquiry. So on and whole, it was a complicated process, and this is a specific section for a specific condition that would come into operation. But yeah, that remains a little important for you too, because it has been asked recently into 2012 May, and that was a 8-mark question. So yeah, that could sound to be a little critical for your exam, because 8 marks is a very big deal in CA final. So yeah, again in that question too, you were given the entire case that there's a construction company who gets into this work. It is not being able to pay dividend, so it wants to give out interest to the shareholders. Please mention the procedures. So when this kind of question comes, you'll have to jot down all the things that we have just discussed in the entire topic, right? Beginning from the authorization to the rate of interest to the inquiry of central government, everything, right? So that will be all for the day. This is Abhinay Gupta signing off. Thank you.